to the law school, and thank you all for competing. And it's been a really good competition so far. So traditionally we sort of go over the problem, which is down in the program. So this is an environmental one. This is about the Commonwealth Generating Company, ComGen, which is a utility company which owns a coal-fired electric generating plant in Vandalia that is aging and is set to retire a coal ash pond that's in the process of closure. And then SCRAP is a national environmental and public interest organization with members located throughout Vandalia. And SCRAP has discovered that ComGen has been discharging PFAS from the outfalls of its coal-fired power plant, and that ComGen's coal ash impoundment is leaching high levels of arsenic and cadmium into the groundwater around the facility. And SCRAP faces several challenges. First, as to the PFAS discharges, and ComGen has a NPDES permit for its discharges for its power plant, but the permit is silent as to PFAS. So while the 12th Circuit has adopted a case that potentially allows a lawsuit for an unpermitted discharge in such circumstances, SCRAP also faces new challenges in light of the Supreme Court's recent reversal on the Chevron deference doctrine. So as to the coal ash pond, because the cadmium and arsenic have not yet reached any surface waters, but rather is only contaminated groundwater, SCRAP faces standing challenges and statutory interpretation problems over whether it can bring a RCRA citizen suits against ComGen for its leaching coal ash ponds. So after the briefing from the lower court, ComGen ultimately prevailed in its motion to dismiss in the district court, and now on appeal to the 12th Circuit Court of Appeals, the court has ordered that SCRAP and ComGen brief the following 4 issues, which are detailed in the program. And so an attorney, Amanda Demerly from Appalachian Mountaineer Advocates, has written the problem for us, so we thank her for that. And so now we'll have Alex, our Vice Chief Justice, introduce the judges and the finalists.
So we're really excited about our final round panel today. It's made up of all federal judges from the state of West Virginia. So first we have the Honorable Judge Trumbull out of the Northern District of West Virginia, Judge Alloy, also out of the Northern District of West Virginia, and Judge Reeder out of the Southern District of West Virginia. We're really grateful for the time and commitment that they put in to this final round. As for our teams, we have one team from the University of Virginia and the other from Louisiana State University. These teams, there's no way around it, went through the gauntlet to get here. We had over 20 teams from schools around the country. They went through, this has got to be about their 8th argument at this point. There can be little doubt that these 2 teams are really deserving to be here today. So without further ado, let's bring out our judges.
All rise. Oyez, oyez, oyez. All persons having business before this honorable court are admonished to draw near and give attention, for the court is now sitting. The case of stop coal combustion residual ash ponds versus Commonwealth Generating Company will now be heard. And will the parties please briefly introduce themselves and who they represent, starting with the appellant.
Thank you. You may be seated.
Nathan Martin, counsel for the appellant. Anthony Teresi, counsel for the appellant.
Lauren Stock on behalf of the Appellee, Commonwealth Generating Company.
Jason Parker on behalf of the appellee, the Commonwealth Generating Company.
All right, thank you. Thank you. Good afternoon, everyone. We're scheduled this afternoon for oral argument in this matter, and we'll turn to the appellant first. Scrap, it's up to you, sir. Who's going to speak first? All right, sir, go right ahead.
Thank you, Your Honors. May it please the court. My name is Nathan Martin, counsel for the appellant, stop coal combustion residual ash ponds. We'd like to reserve 3 minutes for rebuttal.
So granted.
Thank you, Your Honor. Today, I'll be addressing issues 1 and 2, which implicate the Clean Water Act, while my co-counsel will be addressing issues 3 and 4, which implicate the RCRA. We believe that this court, or we ask this court, to overturn the grant of a 12B6 motion to dismiss for 3 reasons as regards to the Clean Water Act. The first is that despite Loper Bright, Piney Run is good law. Loper Bright explicitly states that reliance on Chevron alone is not a good enough reason to overturn precedent. The second reason is that under Piney Run, ComGen's discharges do violate the Clean Water Act, given the test that is presented in that case, specifically that the discharges were not within the reasonable contemplation of the permitting authority, nor they disclosed the permitting authority. And the third is that even if this court does set aside Piney Run and re-examines the statute on its own, it will find that the rule in Piney Run is the most accurate reading of the statute. Unless Your Honor prefer otherwise, I'll start with issue 1.
Go right ahead, sir.
Thank you. Your Honors, Loper-Bright, while it does undercut Chevron deference, does not undercut cases which rely on that precedent. Your Honors, Chief Justice John Roberts specifically states that mere reliance on Chevron is not enough to overturn precedent with regards to stare decisis. Your Honors, this is a case about statutory interpretation of precedent, And Your Honors, precedent and stare decisis is at its strongest in these situations because Congress has the ability and the opportunity to change the law if they dislike what the courts have done. In re Ketchikan Pulp was decided 27 years ago. Piney Run 24. Congress has had ample time to change what the courts have done with regards to the permit shield defense and how it's been interpreted.
Well, but what Congress hasn't done, doesn't Loper-Bright really open the window to allow a different interpretation?
It's our opinion that it does not, Your Honor. We believe that in this instance, Comgen challenges the Piney Run decision because of its Chevron reliance, and that alone is not enough to overturn a
So
decision.
Loper-Bright isn't as bad as we all thought. The sky is falling, that there is no more deference to experts in the field?
No, Your Honor. To begin with, Loper-Bright does allow for Skidmore deference to continue, and in addition, it explicitly makes an effort to not disturb long-settled precedent as this is in this jurisdiction. We adopted this case and this reasoning 7 years ago. Parties have relied on this. And specifically, if in Hilton v. South Carolina Public Railways Commission, the Supreme Court recognized that adherence to precedent promotes stability, judicial respect, and predictability for the parties. There are significant reliance interests at play here. Private actors and the regulatory agency have relied on this rule in the permitting scheme thus far. We do not believe it would be appropriate to set aside that and disturb what is settled precedent.
Well, say it is settled precedent, but your real problem here is that you're wanting us to accept your argument for an item that wasn't really particularly monitored by the EPA, and we're talking about PFAS, something that they would have been unaware of.
Yes, Your Honor. To address that point, this goes into the Piney Run test. Specifically, there is a burden of disclosure placed on the applicants. Judge Wilkinson, in the case of Southern Appalachia Mountain Stewards v. A&G Coal Company,
Was
recognized.
this on the list of items they had to disclose? My
They were-
understanding is it was
It's
not.
my understanding it's not.
Understood, Your Honors. This in particular is an individualized permit, not a generalized one. The permitting authority has the authority to, and in this case did, ask about specific pollutants that are not listed in the EPA's tables or VDEP's tables.
Did ComGeneral know about this PFAS?
That's unknown at this time, but given the procedural posture, we can, Comgen knew, the employee may not have, that was asked in the email.
They knew and didn't disclose it, right?
Yes, Your Honor, that's
But
correct.
didn't the DP, the VDP, also know about it as well? Didn't they know that these contaminants were also contained in most coal ash?
Yeah, that's what I was going to ask.
Good question, Your Honors.
Good question.
Great question.
Great
I
question.
would have asked it too.
great
That is correct, Your Honors. VDEP was aware that it's associated with those byproducts. However, when they specifically asked Comgen if PFAS was located in the discharge, which does in part originate from those byproducts, they told them, well, they assured them that they had no knowledge of that. Now, that was not correct, Your Honors. In the record, it states that since 2015, Comgen has been testing for and has records showing PFAS in the discharge. As far as
But if they, all right, they didn't disclose it, but the fact is the DEP was aware of the existence and still didn't require it as part of the permit process.
Well, Your Honor, they weren't necessarily aware it was in that discharge. They know it's in the incinerator residue, but they don't know if it's in the actual discharge itself. While it may incorporate parts of that, it's not necessarily going to have PFAS in it per se. Which
But
is,
wouldn't it have been within their reasonable contemplation since they did know about it?
it might have been. Had Comgen, which has been testing their wastewater, didn't tell them there was no knowledge of that chemical being within the discharge. Your Honors, the burden on the applicant to disclose accurately is an incredibly important part of the permitting scheme. In this instance, Comgen, we can presume, lied about a chemical which, as the
How
environmental
was it
work...
discovered anyway?
Yes, Your Honor. We don't have any information about whether or not that was a direct lie, but for the purposes of this procedural posture, we can assume
Well,
it
did you all
was.
do your own testing?
We eventually did, Your Honors, but this was long after the permit was granted.
Okay.
We'd like to note that the burden here was intentionally placed on the applicants to disclose because the statutory scheme and how it works is that one burden is placed on the applicant, one burden is placed on the regulating agency. The regulating agency receives information from dischargers, after which they are to view the waterways in which they know multiple people are discharging into and to balance the chemical and biological health of those waterways. They are in the best position to understand what levels are acceptable in the water, but COMGEN's in the best position to understand what's in their discharge. And Your Honors, they had an obligation under Piney Run to notify VDEP about that. And incorporating the disclosure requirement from Enri Ketchikan, which, again, Congress could have changed but chose not to do so.
Let's go back to Piney Run, because I'm not convinced that you satisfied me, because you're operating on the assumption that Piney Run controls, and
Yes,
and
Your
I think Loper may have changed that whole story. So tell me again why it is that you think Piney Run is what we're bound by, and how this court should decide this case.
Yes, Your Honor. We believe
And
that
how
Piney
does that fit with the logic in Loper Bright?
We believe it does, Your Honor. Loper Bright did overturn Chevron deference. We recognize that, and in future cases, courts are not bound by and in fact cannot engage in that. However, in this instance, this is an already settled piece of precedent in this jurisdiction, and Loper Bright chose not to unsettle already settled precedent and not to disturb reliance interest already at play. They even noted that the decision in Chevron about the EPA's behavior on the Clean Air Act would have been acceptable to
Well, if you follow that to its logical extreme, then nothing's ever going to change. And Loper Bright is pretty meaningless.
And there are some distinguishing factors between there are distinguishing factors as well between the cases that you cited in relation to the types of pollutants and the exceptions that were granted for it.
I understand, Your Honor. I imagine you're referring to the statutory v. non-statutory pollutant
Yes,
nature
sir.
issue? Yes, Your Honors. In this instance, the rule promulgated in Piney Run and Enri Ketchikan, as well as the other circuits which have adopted this, including the 6th, 9th, and 4th, as well as this one, is a broad test. It's not only confined to non-statutory pollutants, to statutory pollutants. If it was, it would undercut the regulatory scheme. Because, especially in individualized permits, where we do not have a table specifying what level of pollution is okay for certain chemicals, the reliance on the disclosure of the private actors is even greater. And this would, and speaking as to if Piney Run does not control, we still believe that reading the statute at bar, 1342K, which is the permit shield provision, if you read that, as we've been instructed to do by the Supreme Court, in harmony with other statutory provisions and with a view toward its broader context, as is stated in West Virginia v. EPA, we'll note that there are several statutes or regulations which emphasize the importance of disclosure. For instance, 1318AA places a requirement on private actors who who requested information to provide that to the administrator, as does 40 CFR 122.21G13, which also states that.
So you're suggesting there's independent basis really to hold a Commonwealth generating company responsible for this?
Yes, Your Honor. It's our contention that even if this court does set aside Piney Run and adopt a more restrictive rule, that companies should not be able to benefit from lying to regulators, which is the case at bar here. We do not believe the substantial protection of the permit shield should be given to bad actors.
How did they lie to regulators? I know they
You don't
didn't.
have evidence that they lied that you don't know.
You're correct, Your Honor. We're assuming for the purposes of a 12B6, Your Honor. And can you repeat your question, Your Honor?
Well, it was exactly what I said. How did we know that they were lying? I know it was discovered, obviously, by you that they didn't disclose it.
Yes, Your Honor.
And you got that by subpoena, but they weren't required to disclose it, right?
Well, they were because they were asked, Your Honor, because they
By-
were directly asked by the regulators.
Okay.
But I do recognize that at this stage, and this is actually a great reason why remand is appropriate.
But again, their failure to disclose it when asked seems to indicate that the regulators themselves, the DEP, was aware of the existence of the chemical.
They were aware of the possibility, Your Honor, not necessarily that it was there.
Well, if it was important enough to ask the question, why didn't they require it as part of the permitting process?
Because, Your Honor, the answer that was given by Commonwealth Generating, which I'll note does test their own wastewater and is a massive corporation, who is known to do that, was very misleading. They assured them that it wasn't known to be in the discharge. It follows that the regulator may have, and this is a great factual question for remand, relied on that misrepresentation in granting the permit.
I want to intervene right here real quick.
Yes, Your Honor.
Because you mentioned this, the court threw this out on a 12B6, and you're suggesting that this all may have been premature. What's your best argument for that?
Well, Your Honor, just what we've talked about today. There is a question on if ComGen did know about the dangers of PFAS, which we believe they should, given that the general public was aware of it in the 1990s, according to the Environmental Working Group. There's also a question of, did the employee lie? What level was the employee? How was this email related to higher authorities in the company? There's too many factual questions that we've not been able to discover.
So what's the standard
But-
review on a 12B6 anyway? Are we
Well-
de novo, or do we give them some deference, or what?
Well, Your Honor, you're de novo in issues of law, and you're to take the facts most favorable, in the light most favorable to the appellant or the non-moving party in this case.
And you didn't develop a record in this case, right?
We couldn't, Your Honor. We were
Right,
not allowed to
okay.
discover.
Go ahead, I'm sorry.
Going back to that same issue, because you had mentioned that it's very well known that this is something that would be out there. Well, doesn't that come right back to the reasonable contemplation issue, and that the regulators would know that too, and knew that that was a common element of fly ash?
Well, I hear you, Your Honor. While it may have been a common element in the fly ash, it's not necessarily a common element in the wastewater, which doesn't necessarily contain all of the elements of fly ash, which is why ComGen was asked about it. In fact, it's relatively recent that knowledge of it being in fly ash was developed. Now, we can assume ComGen knew, given the procedural posture and their work, but that's a very good point. It is well known, but because it's well known, doesn't necessarily mean the regulators know exactly where it's coming from at all times, which highlights the importance of disclosure, Your Honors. And in closing, we ask that you remand for further fact-finding, as we believe the motion to dismiss was premature, given the important and material factual questions at bar here. Thank you, Your Honors.
Oh, thank you.
Thank you.
Good afternoon, may it please the court. Anthony Truisi on behalf of SCRAP. We ask the court to reverse the district court's dismissal of the RCRA claims for two reasons. The first being that SCRAP as an organization has associational standing to challenge the adequacy of the closure plan on behalf of its members presently living in Vandalia. To the extent that the district court disagreed with that assessment, we believe it was based on a conclusion that disagreed on the injury in fact in this case. The second reason being the district court relied on the case from Cortland versus Union Carbide to decide that for purposes of Section 6972A1B, there is a dual requirement both for an environmental harm and for an exposure pathway for an adverse impact on human health. We believe that this requirement, this additional element, cannot be reconciled with the plain language of 6972 and ignores the fact that the facts in Cortland are highly distinguishable from what is at case here. Even if this court were to give full force to Judge Copenhaver's decision in Cortland, we believe we can make the argument that there is such an imminent pathway here to an effect on human health. Unless this court prefers otherwise, I'd like to begin with the first issue, which is standing. Associational standing comes from the Supreme Court's test in Hunt versus Washington State Apple Commission. There's a three-pronged test, the latter two of which we believe are readily satisfiable in this case. The interests here are certainly germane to SCRAP as an organization.
I don't think the issue is whether or not you have associational standing. I accept that. The issue is whether you suffered any injury in fact, and is all this just way too speculative? Because you can't point to an
What
injury in
is the
fact.
injury in fact?
Yeah.
Yeah.
What is exactly that you're contending is the injury in fact that we should rule in your favor for?
Your Honor, I take this from the Supreme Court's decision in Laird v. Tatum. There it said the injury is in the form of a fear of a specific harm that will arise from the defendant's actions. Now, that's a paraphrase because the court in Tatum said may arise. We believe here, because we can identify an articulable mechanism by which the harm will be
So far,
actualized.
you have something that may be environmental, but what's the individual harm? I mean, there are no homes near this. You can't point to any single individual that's been harmed by anything.
Well, Your Honor, SCRAP members do quite often recreate and use the Vandalia River for aesthetic value. There's also SCRAP
Any
members.
dead fish floating in the water?
The fish would be considered a living organism, and to the extent that this court finds that the adverse impact goes beyond human health to affect organisms, we believe unless the river is devoid of all life, there is an imminent impact that will be actualized once the contaminants, here being arsenic and cadmium, which are highly toxic, reach the river. Now, the important.
they
But that's the
have
whole thing, they
That
haven't
hasn't
reached the,
happened,
that
though,
hasn't
correct?
occurred yet, has it?
It has not occurred yet, Your Honor, and to the extent that,
And at what point do they anticipate that it will reach?
well, Your Honor, there's no way to certainly say whether or not it will occur today or tomorrow. But going back to Laird v. Tatum, well, Your Honor, to the extent that we can identify a mechanism, the court in Laird v. Tatum says that we can move from the world of this being a fear of what may occur to an injury in fact. And just 12 years ago in Clapper v. Amnesty International, the Supreme Court did say that in order to satisfy this requirement, you need to show the harm's actual, imminent. It didn't stop there. It then said, or forwards, or a substantial risk. Now, the Fifth Circuit took that and it interpreted it to mean that the imminence requirement is somewhat elastic. And that leaves some.
So how elastic? I mean, months, years, decades?
Well, no, Your Honor, I think the Ninth Circuit answered that question quite clearly, and I believe the Seventh Circuit adopted that interpretation, which is the operative question is whether or not there is a natural probability that the harm will occur, and that's from NRDC versus US EPA. And here we believe that, taking the light most favorable to the appellant, which is scrap, we believe the answer is yes, because the mechanism by which the harm will actually be realized is quite clear. ComGen wants to cap the impoundment in place. The impoundment as it currently exists and has been leaching by liberal estimates for at least 10 years is set below sea level, so it's in contact presently with groundwater.
How far is it from the river?
Your Honor, that's not in the record, and that's also a point to remand this on, is to identify how far has it gone, which to present estimates is 1.5 miles. But that estimate, which ComGen's experts said it won't reach the river within the next 5 years.
They had some testing ponds around it, right? You all put them in.
They have some testing ponds, Your Honor, but to the extent that those ponds were taking measurements based on the uncapped impoundment. Now, this plan won't be finalized until 2027, according to ComGen. And what our theory is if you are going to cap an impoundment in place, you surely do prevent the ability of rainwater and environmental factors to seep through to the groundwater. But what you don't do, and this is the inadequacy, is you don't line the sides of the impoundment to keep what's already there in place.
Well, this thing isn't lined at all, is it?
It's not, Your Honor, and that's the problem, because the groundwater is free-flowing, and the record to this extent has shown it is flowing in the path of least resistance, which is in the direction of the Vandalia River. Now, we believe there's a mechanism here that the capping will accelerate, which is when rainwater comes 50 feet to the capped impoundment, it seeps into the groundwater, and it causes pressure in that pocket, pushing it in the path of least resistance. That water is part and parcel at this moment with cadmium and arsenic contamination.
How does the fact that those substances have been leaching out for 5 to 10 years before this capping was even contemplated affect your right to relief in this matter?
Your Honor, it's our position that ComGen, to the extent that they want to implement this closure plan, takes the impoundment as it is. The fact that by liberal estimates for 10 years, by conservative estimates for 5 years, this leaching has been occurring, does not change the fact that to the extent that they now want and have been permitted with the authority to implement a closure plan, they must meet that burden that they've assumed and prevent further leaching,
What do
because
they need to do to prevent it? What would you ask the court to do?
to use its equitable relief powers to say that, in addition to putting that lead capping and covering with soil to prevent the seepage, put lead lining on the sides going all the way to what I would assume would be the bedrock, and that's a point for remand, to identify how deep it must go to actually cap the groundwater to prevent further leaching. Because at present, what the record does suggest is it is leaching in the direction of the Vandalia River. And yes.
How does the closure plan really fix your problem? How is it going to change? I mean, and in addition to that, the fact that the closure plan is not complete at this time, where are we going with this as far as how you're going to be able to fix it by changing something in the closure plan, in particular since arsenic and cadmium haven't even reached the river at this point?
Well, Your Honor, to the extent that it hasn't reached the river, I believe under the Clapper standard of substantial risk or even imminence, it's well in its way of the mechanism of reaching the river.
Is this river the source of drinking water for a community?
The main source for the Mammoth chapter in Vandalia, of which the scrap members are part of. But
So what was that? Do that again?
it's scraps chapter in Mammoth, Vandalia.
Okay.
That's the community on which the Vandalia River is the main source of drinking water.
I see.
And to the extent, and to answer your question once again, if you install those lead lining, what you do is you cap the current leaching in place. But this is the problem because scrap hasn't had to stay in court. If we open the doors to discovery in this case, it may come out that, for example, if we don't cap it right now on the sides, if you add that lead capping on top, it might actually accelerate the mechanism towards the river, because at that point, clearly the water can't come down, it can't go up because it's capped, it's only going to go in one direction, and at current, that's the direction of the Vandalia River. And to the extent that there will be a harm, quite literally to the point that it is the main source of drinking water, cadmium and arsenic will touch the Vandalia River, and at that same time touch the lips and skins of Vandalians who rely on it for drinking water. Not to mention the fish and living organisms it will kill along the way. And for this purpose, I'd like to move on to the second part of our argument, which is the RCRA and its plain language. The RCRA is quite clear on its face that either a harm to the environment or to human health is sufficient to sustain a claim under its plain language.
Yeah, because this year you don't have any humans being hurt, so harm to the environment doesn't give you any standing to make a claim.
Well, Your Honor, to the extent that for a standing analysis we're able to satisfy that there is a nexus to a plaintiff who would be harmed by this environmental harm, we believe that a test that's meant for an analysis of constitutional dimension will at least satisfy a statutory requirement that says that the harm must be either to health or the environment. And I think that's what Congress wanted to do here. They wanted to empower citizens as private attorney generals, assuming they have standing to challenge environmental harms alone. Congress knows the difference between and or. In fact, they used both of those words right here in the same sentence. And what that would suggest is Congress intentionally legislating wanted to ascribe to those terms their plain meaning. The Supreme...
So, I want to ask you about congressional history. Did it ever talk about environmental harm being enough?
Well, Your Honor, I believe that the RCRA was meant by the legislature to be a statute that picked up the scraps of the CWA. And to the extent that it did so, the CWA was limited to navigable waters. And this wanted to fix what was left over. And to the extent that they did that, I believe the focus was on environmental harms that the CWA didn't cover, contingent upon standing being satisfied by private attorney generals. So I think the legislative history goes part and parcel with that. And if we look at one of the first cases after the CWA, which I believe was right here, Worth v. Selden. Worth v. Selden stood for that proposition that although the statute, Congress can legislate around Article III standing for purposes of creating a cause of action, the courts, they may rely on courts then to identify that the plaintiff does have Article III standing in the first instance. And I believe that's the purpose of saying that there's a cause of action for both the environment and for a pathway to
What
health.
about the district judge's argument that not only do you have standing for environmental harm, but the point is that the harm that's being suffered is historical. It's already happened.
Your Honor,
It doesn't have anything to do with the closing of it.
from the opinion, there was a quite an instructive example, which is if you took the plaintiff's home and you put that property right on the path of where the contamination was happening, that plaintiff would have standing because it touched his property. Clearly, Congress knew how to use the word property, but it chose the word environment. And I believe it did so because it can rely on courts to do that Article III standing analysis, establish a sufficient nexus and a particularity to the individual private attorney general.
So you think we should consider the historical?
Well, yes, Your Honor. The history here, if you want to consider the history of the RCRA, it applies spot on to this set of facts right here. Because the CWA claim is focusing on PFAS because it has reached the river. But to the extent that it is well on its way to reaching the river at this present moment.
You've said that a couple times. What's the evidence with regard to an exposure pathway to the river? And isn't that required for there to be imminent and substantial endangerment?
Well, Your Honor, I would refer back to what the Supreme Court said in Clapper, which is to the extent that we can show that there's a substantial risk or by a natural probability. Here, quite ironically, the probability does come from nature itself, where the rainwater is increasing the pressure in the groundwater pockets. It's pushing the water in a certain direction, and that's the Vandalia River. To the extent, if it'll ever reach there, I believe that's a fact to be brought up on remand to understand whether or not there's any topographical barriers to it actually reaching the river. But at current, that harm is in the mechanism of being actualized. And although this court, to some degree, must be able to say something about timing to reach an imminence decision, we believe taking the light most favorable to scrap, we can arrive at the conclusion that although it may not reach the river today or tomorrow, sometime in the next 5 years, it will rain. And what the rain does, because the rain is imminent, is it contributes to that mechanism and acts as an accelerant, more so than the capping itself acts as an accelerant. And turning once more to the legislative intent, I believe Congress very much did want to rely on courts doing Article III standing analysis. And I think that's what Judge Copenhagen was going to.
Well, what evidence do you have now there's environmental harm?
Well, the presence of cadmium and arsenic alone in the soil or in the groundwater does harm any living organisms therein, to the extent that that is one element in addition to the fact that it is well on its way to a very popular source of drinking water for Scrap's members living in Vandalia. And once again, it touches the property of many Vandalians as it goes along. And I believe that what the RCRA was meant to do is empower people with standing to challenge that pathway before the harm is actually realized. And to the extent that that pathway does exist and is presently in the process of being realized, Scrap is bringing this claim on behalf of those members whom Congress wanted to empower. And the issue, to the extent that courts believe that the RCRA allowing the environment alone would jeopardize standing requirements, that falls on courts to recognize that injury to the individual plaintiff is not required for the RCRA, but it is required for Article III standing. That's what we believe that the Supreme Court, that Congress was relying on when it determined that standing is the legislative backdrop against which Congress legislates. I see that I'm running low on time, Your Honor, so I'd like to conclude by saying, to the extent that there are no barriers, statutory or topographical, shown to this point, that once the cadmium reaches the river, it will not eventually find its way into cups and glasses of Vandalians, we believe that is the point to remand on. To the extent that the capping procedure will act as an accelerant to that pathway, that is also another fact to be brought up on remand. And taking the light most favorable to the appellant in this case, which is Scrap, we believe that to the extent that we can show that that mechanism has already been put in place. Your Honor, I see my time has ended. Unless there's any other questions, we are happy to rest on our brief. Thank you, Your Honors.
Thank you.
All right. We hear from Conjen.
May it please the court. I am Lauren Stopp, and I, alongside my co-counsel Jason Parker, represent the Commonwealth Generating Company, or ComGen, the appellee in this matter. I will address the first two issues on appeal before the court today regarding the Clean Water Act, or the CWA, and Mr. Parker will address issues 3 and 4 on the Resource Conservation and Recovery Act. Your Honors, this case is about protecting reliance interests on established regulatory frameworks, particularly where entities have followed all official regulatory guidelines. Permits provide stability in the system, and entities must be able to rely on their validly issued permits. ComGen respectfully requests that this court affirm the judgment of the district court for 2 reasons. First, ComGen's discharge of per- and polyfluoroalkyl substances, or PFAS, is not an unpermitted discharge under the Clean Water Act.
But it's harmful, isn't it?
Well, Your Honor, first I would like to point out that PFAS...
I mean, should we just say too bad because you're poisoned, but it wasn't identified? Even when you knew about it and lied about it and didn't disclose it? Is that the world we live in?
No, Your Honor. And
Okay, good.
ComGen has been a presence in this region for over half a century, powering this region, employing individuals and citizens of Vandalia.
I
and of course,
appreciate that.
wouldn't-
Just don't want them to poison anyone.
Of course, Your Honor, and would never want to be, again, not comply with regulatory guidelines that are in effect. However, that is not what happened in this case. First, PFAS are not statutory pollutants regulated under the CWA. And second, even if they were, ComGen is protected for their discharge.
They are harmful, though, aren't
Well,
they?
you talk about the fact that they've done wonderful things for the community, and yet we talk about a harmful chemical that they are aware of, and there's no duty to disclose because it's not required, and maybe it wasn't on the permit application. So I guess that just water under the bridge, forget about it, right?
Bad water.
Bad water.
No, Your Honor. I would point to 33 U.S.C. 1362(6), the definition of pollutant under the Act. And pollutant is defined quite broadly, conceitedly, encompassing almost any conceivable chemical, biological, or industrial substance. However, the EPA has never required that permit applicants provide every substance which might be present in its discharge of pollutants, because as even the EPA has recognized, doing so would be almost impossible and would subject
I understand,
entities
but
to
you
almost
knew
endless
about this one.
liability.
You knew about it. You were testing, you understood it, you knew it was bad, you chose not to disclose it. I'm not talking about some unknown arbitrary thing, you knew it.
Your Honor,
When your employee was inquired about it by the Vandalia DEP, what duty did they have to honestly answer that question? Because the crux of it is that, the argument is at least, they didn't truthfully answer that.
yes, Your Honor. crux of this argument is indeed whether ComGen complied with mandatory disclosure requirements under the CWA. And those disclosure requirements are outlined and identified in 40 CFR 122.21 E, F, and G. Those regulations contemplate that disclosures will be made on official permit application forms provided by the permitting authority. It is those application forms which form the basis of the permit that is later issued. There is also an attestation clause under the CWA, 40 CFR section 122.22, which concededly requires that all information provided to the permitting authority be true, complete, and accurate. However, what is attested to are the official permit documents, the official permit application and forms, along with any official requests for monitoring and monitoring reports. Those are what are attested to as being truthful, complete, and accurate because, again, those official documents are what form the basis of the permit that is later issued. The Vandalia Department of Environmental Protection had scientific evidence that PFAS may be present in these waste streams.
You did too.
Your Honor, we were,
But you put it there. I mean, you were testing it. You knew it.
Your Honor, so PFAS were monitored by ComGen going back to 2015, but there is a big difference between monitoring for substances in your discharge and disclosing pollutants, testing for pollutants. At the time that ComGen's permit became effective, on September 1st, 2020, PFAS were not recognized by any agency as pollutants under the understanding of the CWA. It was not until 13 months later, in October of 2021, that the EPA first even turned its attention to a potential PFAS issue. At that time, they introduced the PFAS Strategic Roadmap. And again, that was the very first time that a regulatory body had turned its attention in that way to a potential PFAS issue. So the dangers of PFAS, this is not an understood pollutant as, some other historical statutory pollutants. And the science and the understanding of PFAS has evolved, especially over the last few years. The VDEP at any time had the authority as the plenary power to issue these permits, to modify or update ComGen's permit to reflect these new scientific understandings, and yet they chose not to. And again, they had this information, this scientific study at the time, and they did not include it in the formal permit application. They would have been well within their right to include PFAS parameters on the permit application, as well as request official monitoring reports, testing, or even to enter into ComGen's property and test themselves. However, they chose not to do that, and therefore no formal disclosure requirements were triggered during this process.
Sounds like to me a company just holding its breath so it can get by. And it's, I don't think, again, that's appropriate conduct. Tell me why Piney Run doesn't apply in this case.
Well, better yet, why doesn't Piney just control?
Yeah.
I mean, if Piney Run controls, why are we even here?
Yes, Your Honor. So Piney Run is inapplicable in this case for two reasons. First, a threshold issue being that Piney Run is really inapplicable to the facts of this case.
Why?
As you discussed earlier with opposing counsel. So in Piney Run, the court was tasked with determining whether the discharge of heat, which was not evidenced from the face of that permit, was in violation of the permit or protected by the permit shield. However, heat is a statutory pollutant. It is enumerated under the definition of pollutant in the Clean Water Act. It appears on every CWA permit application currently in circulation by the EPA, and it appears in the much more detailed CFR requirements for disclosure. However, as I've alluded to, PFAS are not statutory pollutants regulated under the CWA. There are currently no effluent limitation guidelines
All
set
right,
for
so
PFAS.
we've identified a distinguishing factor. Is that enough to set it aside?
No, Your Honor. In addition, it is also inconsistent with the Supreme Court's recent ruling in Loper Bright Enterprises v. Raimondo. And concededly, that
But
case...
Loper Bright says that prior decisions are still valid decisions. So how is it inconsistent with the Supreme Court decision in Loper Bright?
Yes, Your Honor. So again, concededly, that case did preserve the holdings of cases that relied on Chevron
Which again, why are we here if that case is still controlling?
However, it did provide that to say that a case relied on Chevron is an argument that the case was wrongly decided. And in that vein, Piney Run, which relied exclusively on Chevron deference, was wrongly decided. there is a pre-existing legal precedent out of the Second Circuit, Atlantic States versus Eastman Kodak Company, which more faithfully interprets the plain meaning of the permit shield provision. And that provision is 33 U.S.C. 1342K. It states that compliance with a permit issued pursuant to this section shall be deemed compliance for purposes of the Clean Water Act. And in Atlantic States, the court held that as long as a party has a valid permit, has complied with that permit, and has complied with the official disclosure requirements mandated under the Act, they should be protected from liability.
Isn't that just incentive, though, for them to lie on the permitting process so they can just get by with what they disclose?
Absolutely not, Your Honor, because again, had the VDEP included PFAS parameters on the official permit documents or requested official monitoring reports, an official disclosure requirement would have been triggered, and ComGen would have complied with those requirements. There may be hundreds of communications between the permitting authority and the permittee during the permitting process, and they can range from, again, emails, text messages, oral conversations. That's why that attestation clause is so important. It is what controls what ends up on the permit, and it is why—
So if scrap can show that a chemical that your company is discharging causes harm, you're saying too bad, too sad, we didn't know about it, wasn't required in the permit, so you haven't suffered anything?
Yes, Your Honor. In this situation, the reliance on a permit issued is really what is important here. Companies rely on these permits to be in compliance, and it is a reliance on the agency to identify the pollutants, those harmful pollutants, and regulate them through the official permit process.
Assuming the Pliny test still does apply, though, can you prevail?
Your Honor, we believe that we can. Again,
How?
because we have complied with the validly issued permit and with all official disclosure requirements under the Act satisfying the first prong. And PFAS were in the reasonable contemplation of the permitting authority because it was the VDEP who asked this question. They had this scientific evidence as seen on pages 4 and 5 of the record. They knew that it was potentially included in this discharge. And had they been worried, again, they could have included those parameters on the official permit documentation, requested official reports, or at any time over the last 5 years, modified ComGen's permit to reflect new scientific understandings surrounding PFAS. They had this information prior to permit issuance, so it was certainly within their reasonable contemplation. However, again, under the plain reading of the statute, Atlantic States provides the most faithful interpretation of the text. Compliance is defined by Merriam-Webster Dictionary as conformity in fulfilling official requirements. And again, those official requirements contemplate that disclosures will be made on forms provided by the permit writer. Additionally, the permit shield provision states that compliance with a permit issued pursuant to this section shall be deemed compliance for purposes of the
I
Act.
understand the compliance argument. I guess what's bothersome to me is that, at least the record indicates, that ComGen knew of PFAS and then just did not disclose it, knowing that it was harmful or could be harmful. And I don't know how you square that, just because, well, we didn't have to disclose it because it wasn't on our application or permit. You knew about it. I mean, is it just that we can't trust you on those things?
No, Your Honor. Again, although PFAS were being monitored since 2015, again, the knowledge of PFAS and its potential dangers, it was unknown at that time. Again, PFAS were not regulated, not by the VDEP, not by the EPA at that time, and in fact, they still aren't. The EPA's most recent update to the strategic roadmap that was released in November of 2024 stated that the EPA now plans to propose a rule that would require PFAS data to be reported as part of these applications.
Okay.
And that admission alone is enough to make clear that at the time, these were certainly not required to be disclosed during the permitting process, and in fact, they still aren't.
What explanation did the district court provide for not following precedent within the district and going out of district to make this decision?
Yes, Your Honor. Again, the factual distinction of the case was important, and also—
Did the district court explain that in its ruling?
They actually applied Atlantic States in light of the Supreme Court's ruling in Loper-Bright, Your Honor, as, again, a more faithful interpretation of the permit shield provision.
And disregarded our precedent, because we adopted Piney.
Yes, Your Honor. And again, after
Pretty bold move.
Post Loper-Bright, Your Honor, looking to the interpretive methodology is certainly appropriate to look at precedent and determine whether it
Yeah,
should
but
be.
doesn't it require a more thorough explanation than what was provided?
Yes, Your Honor, and certainly we hope to provide that explanation today and hope to maintain.
I'm waiting for your explanation.
Excuse
I was
me?
waiting for your explanation.
Yes, Your Honor, that, again, post Loper-Bright, looking back to this interpretive methodology, the Fourth Circuit relied exclusively on Chevron deference. And again, EPA guidance has not been consistent on this issue. In one breath, the EPA, in memorandums to its regional directors, has conceded that it would be impossible to identify and rationally limit every substance which could appear in a permittee's discharges, while in the same breath, in Ketchikan Pulp Company, which formed the basis of Piney Run, requiring that a permittee disclose every potential substance which might be present in its discharges in any amount to later shield itself from liability. And a reading of the permit shield provision, that reading of the permit shield provision would be almost no shield at all, rendering an entire section of the Clean Water Act almost meaningless. And instead, Atlantic States provides the more faithful reading of that provision, because ComGen has, at all times, complied with its validly issued permit and the official disclosure requirements mandated under the Act, and because a best reading of the permit shield provision would protect it from liability, ComGen respectfully requests that this court affirm the judgment of the district court in its entirety. Thank you.
Okay,
Thank you.
Thank you.
counsel.
Permission to approach the podium, Your Honor.
You may, Mr. Parker, you may approach.
I think you can wait for you to tell him to get going.
Oh, sir, you may proceed. I apologize.
Thank you, Your Honor. May it please the court. My name is Jason Parker, and I'm also here on behalf of the appellee, the Commonwealth Generating Company, also known as ComGen. As my co-counsel, Lauren Stopp, stated, I will be addressing the third issue of why Scrap does not have standing to pursue a 6972A1A RCRA claim attacking ComGen's closure plan, and the fourth issue of why Scrap cannot pursue a separate claim under RCRA statute 6972A1B for imminent and substantial endangerment. ComGen respectfully requests that this court affirm the district court's ruling in its entirety. On the third issue, Scrap does not have standing to challenge ComGen's closure plan for two primary reasons. Number one, Scrap's injuries are not fairly traceable to the adequacy of ComGen's closure plan. And secondly, Scrap's injuries would not be redressed by a favorable judicial decision here today. On the fourth issue, Scrap's imminent and substantial endangerment claim would fail for two reasons. Number one, they lacked no allegation to any living population being endangered. And secondly, by broadening RCRA's scope in this interpretation under this portion of the statute, it would negatively impact the policy going forward here today.
It's the Environmental Protection Act. I mean, it's about protecting the environment, right? I don't get where you all say, though, an injury to the environment is not a harm under the act. I don't know how you can ever say that an injury to the environment does not ultimately affect people. It's just so academic to me, and I can't believe the judge hung his hat on it.
So under that statute, Honor 6972A1B, that proceeds to the fourth issue here at hand today of whether an imminent and substantial endangerment is at harm to the health or the environment. Your Honor, you previously asked about legislative intent in this, and the 98th congressional session in the 80s, when they amended the RCRA Act, Congress left this judicial interpretation into the plain reading of the statute. The case in the Southern District of West Virginia in 2023, the Cortland Corporation case, decided that if it were to be interpreted that a living population were not required, this would in turn present a problematic standard for energy companies going forward, where any mere contamination would allow this inflow of cases to come against energy companies when there's no allegation.
Isn't it what the plain language actually says, or environment?
Yes, Your Honor. It
I
does-
mean, so how do you exclude or environment from that? I mean, how do you just ignore that language?
Your Honor, regarding or environment, to ignore that language, you can see it as the environment of a living population in the case. By the fact, the
By
record
what
shows
definitional standard did you come up with that?
Cortland Corporation versus Union Carbide in 2023, the district court in the Southern District of West Virginia concluded in this analysis that by allowing interpretations of that or environment to not include a living population of the environment, this would in turn be a misappropriation of the reading of the statute. And it can be seen from the Supreme Court case in 1996 in McGrigg versus KFC Western, how these words in the statute should be interpreted. The court said there that the may present in the third prong of RCRA statute 6972A1B implies that the endangerment is only imminent if the threat is to occur immediately. This implies that there must be a threat present now, although the impact of the threat may not be felt until later. By interpreting the Supreme Court's ruling in McGrigg versus KFC Western,
This whole notion of eminence, how you're defining it, here's the whole problem. I mean, this is located near a river, which provides drinking water for a community. We know that it's leaching into the environment now in the soil. It's gonna happen. So do we have to say, guys, wait till we have some dying people, then you have standing? I mean, that's why we have this standard of eminency and also harm in the future. Try to head that off. And you can do it, and you know it now. Why shouldn't we remedy that?
Your Honor, regarding that question, the imminency of this issue at hand is shown in the record on page 8 that yes, this has been leaking for the last 5 to 10 years since the ground monitor monitoring wells were installed in
It's not gonna stop
2021.
on its own, is it?
The record also states on page 8 as well, Your Honor, that there is no evidence that any arsenic or cadmium will reach the Vandalia River or any public water drinking supply in the next 5 years. To transfer back to issue 3, Your Honor, concerning the adequacy of our closure
So
plan.
people won't need water after 5 years?
And Your Honor, that exactly transfers back to issue 3, Your Honor, where the closure plan, the adequacy of it regarding standing in this analysis, our closure plan will
What
clean.
about this closure plan? Is it true they just want to put a cap on top of it?
Yes, Your Honor,
Well,
that
doesn't
is,
that just force everything down? And I don't know, seems to me sort of
Kind of
make the
kicks the
leach.
can down the road a little bit, doesn't it?
Yeah, a
I
little.
mean, you know, just wait for the next generation to have to clean it up. We don't have to, right?
no, Your Honor, the method that Scrap is using this plan, it will be spending $1 billion by the year 2031, and this impoundment will be closed and the leaching will be stopped. In 2015.
Oh, it will be stopped,
Yes, Your Honor, by 2031.
and you're gonna guarantee that and assure that.
Yes, Your Honor, in requirements
bond.
with the CCR rule that the EPA passed in 2015 and the state of Vandalia has since
Let's go back to the
adopted.
other issue. You were a little bit dishonest about the existence of certain chemicals in your permitting process, so how can I trust you in this process that you're gonna stop it in 2031?
Because, Your Honor, in this claim, Scrap is filing an injunction to stop Comgen from implementing this closure plan. However, they have failed to state any facts on the basis of their complaint that Comgen is not in compliance with the CCR rule of the closure plan. And to establish this, Scrap must have standing in this case. However, Scrap has failed to satisfy those 3 elements of standing under the Lujan versus Defender Wildlife test. The first one being injury in fact. And Your Honors, Comgen will be completely candid today. We condone that there was an injury in fact and suffered in form of recreational and aesthetic harms. The Friends of Earth case from 2000 has established that that can satisfy injury in fact. However, Scrap has failed to satisfy the latter 2 elements of standing regarding causation and traceability from the Lujan test. To the second element of
Well,
standing.
where else is this coming from? I mean, arsenic doesn't, I mean, it's coming from your pond where you put the coal ash. I mean, where else could it be coming from?
You're exactly right, Your Honor. It's coming from this impoundment, but it is not coming from this plan, which is what in Scrap's complaint, an opposing counsel
Oh, I'm
failed to
sorry,
identify.
go back. Make that distinction again. It's coming from the impoundment?
But what Scrap's complaint is pleading here today is that the closure plan that Comgen is implementing is inadequate, and that this court should enjoin Comgen's closure plan from being implemented. Scrap is pleading,
To make it adequate, right?
the plan at this point in time, Your Honor, is adequate based under the standards established by the EPA and that the state of Vandalia has adopted. Comgen chose the option. There were two options under the rule that you could have chosen with, an excavation in place and a closure in place plan. Comgen chose the closure in place plan, which did require more requirements under the CFR rules.
Which means leaving this 71 acres of just toxic ash in place, right?
In part, Your Honor, no, that is incorrect. Comgen's closure plan in place has several steps that are required further upon the CFR statute. To regard to the first one, in terms of how Comgen does have standing in this case.
Don't we already know that it is leaching into the groundwater? Contaminants are leaching into the groundwater due
That's
to
correct.
water monitoring systems? So how can we be sure that this is not going to continue by the use of whatever plan that you come up with to seal it?
There were no facts alleged by Scrap, Your Honor. That Comgen's plan is not inconclusory with these rules passed by the EPA.
The
Comgen
judge
has,
cut them off, I mean, at rule, by dismissing it, permitted no discovery or anything else.
Your Honor, regarding this plan specifically, it is not traceable to the cause of this closure plan. You asked opposing counsel, Your Honor, should we consider historical contamination when looking at this closure plan? And opposing counsel responded yes, which coincides with Comgen's case, as can be seen out of the Mobile Baykeeper case from the Southern District of Alabama. In that case, it was a very similar factual similarity between the two, as there was an electric plant and a coal ash plant and an impoundment plant owned by Mobile Baykeeper. A RCRA statute under 6972A1A, which, Your Honors, is challenging the closure plan and the permit was brought upon Mobile Baykeeper in that case. However, the court in that case found that there was no standing based on traceability and redressability. But to traceability, they found no standing was present in the case against Mobile Baykeeper against Alabama Power by Mobile Baykeeper due to the fact that the contaminants had been leaking years prior, such as we have in this case.
Makes no sense, though. I mean, we just disregard the history of it. It seems like to me that if you have a history of leaching, which is going to create harm, gives you a greater argument for standing.
Your Honor,
Go ahead.
the Supreme Court in Lujan versus Defenders of Wildlife state that the causal connection, but it must be between the injury at hand, which Comgen has contended to the recreational and aesthetic injuries, and the defendant's conduct. The conduct being challenged in this case is that our closure plan is inadequate. The closure plan did not cause the impoundment to leak, the simple standard. And to further the redress.
That's just so absurd. I mean, I don't know. I mean, to say that, well, yeah, you've had this history of leaking, but that's not connected here because we're closing it. So let's forget all the leaking and let's go forward, which we got to be concerned about that continuing. I mean, it's such an academic argument that ignores our reality, and I'm not thinking much of the case.
Your Honor,
It just makes-
the rules
I
that
mean,
we
the
are.
district judge is so off on that.
The rules that we are complying with state that, at minimum, the unit must be closed in a manner that will control, minimize, or eliminate to maximum extent.
Well, that's the
feasible-
whole point. The closure plan, does it prevent leaching in the future if there's already a coal ash that's already in contact with groundwater? It is by changing the plan in some fashion or enjoining this plan for moving forward, can it be addressed in a different fashion to correct that problem? Because we already know that that's existing and that's occurring, don't we?
Yes, Your Honor, we know that the plant is currently leaking. However, that turns to the redressability point, Your Honor, of how this plan will redress the injury that Scrap is suffering in fact. If this court were to enjoin Comgen from going forward with its closure plan, the leakage would still be continuing. However, if this court should allow and affirm the district court's decision, allowing Comgen's closure plan to continue, we can continue the steps of spending $1 billion.
Well, you're acting like if we would enjoin it, we would do nothing. No, we would say enjoin what you're doing and correct it. Do it correctly to minimize the harm that it's going to cause.
At the end of the day, unless your plan contains some mechanism to stop the contact with the groundwater, the intrusion of the groundwater, then what good is the plan other than to cover it and just, and ignore it?
Cover up, as they
Cover
say.
it up.
Your Honor, we'll be in fact installing the cover, but not to cover up in this case. Comgen, its position is in compliance with these rules that were promulgated. Scrap has failed to state any matter on the face of their complaint of the facts of how COMGEN is the plan is explicitly not in compliance with the rules. But to transfer back to issue 4, Your Honor, which is the imminent and substantial endangerment claim, I know that is of important questions before this court to ensure that these member citizens of Scrap are not being harmly affected by an imminent and substantial endanger. However, it is of this court to acknowledge that energy companies as well will be deprived of their opportunities when a mere contamination standard that has been adopted by other circuits, such as the Third Circuit in Interfaith and the 10th Circuit in Burlington, that a living population need not be required, will create this mere contamination standard, where a energy company such as COMGEN, who acknowledges that the federal arsenic and cadmium and state levels have been exceeded by the leakage, would then be termed in response to an imminent and substantial endangerment, harm, or health, where there is no allegation of any living population being harmed. The 2 cases I previously mentioned that were referenced in the lower court's opinion.
Well, they talk about it, but isn't there eminence? Isn't it reasonable to believe that there will be harm when this arsenic reaches the river and drinking water?
No, Your
I mean,
Honor.
can you sit here and say, don't worry about it, Judge, it's never gonna reach it? It doesn't flow downhill, it won't
Better
get
yet,
there?
Build your
Go
house
ahead.
beside the plant.
Yeah, I mean, it's gonna happen.
Put your house beside it and drink the water that's coming out of the river.
Yeah, it'll be flavored.
To answer your question first, Your Honor, before referring to Chief Judge's question, we can say, if you look at the timeline
Say
here,
1 minute.
if you look at the timeline available, it is established that the closure plan, that the impoundment was leaking 5 to 10 years prior. We are currently in the year of 2025 with the plan being fully completed by 2031 and no evidence in the record on page 8 that any arsenic or cadmium will reach any public water drinking supply.
You're just hoping it doesn't reach until 3032.
By 2030 to 2031, Your Honor, it is well to assume that COMGEN would be in compliance with the last portions of this rule and finishing their $1 billion expenditure to help fund their Building Green Tomorrow plan that they began in 2015.
And keeping our fingers crossed that it actually worked so that those things didn't occur, right?
This plan is adequate, Your Honor, as we've previously established through the rules that there is no factual complaint that Scrap is making where the plan is failing in this aspect. And to briefly conclude on your question you mentioned, Your Honor,
Sir, go ahead.
this case concerns not just the Scrap members and what they wish going for. I see my time has expired. Would you mind if I finish my statement before we're going back to sit?
Briefly, I'll give you that option.
For these reasons, COMGEN respectfully requests that this court affirm the district court's ruling in its entirety on each of the separate claims. Thank you.
Thank you, sir.
Thank you, counsel.
All right, we'll hear your rebuttal argument, sir.
Your Honor, just a few points in rebuttal here. The first is we'd like to point out that in interpreting the Clean Water Act, opposing counsel mentioned the plain language of 1342K, which is the permit shield requirement. We'd like to note that the 4th, 2nd, 6th, 9th, and this circuit have all recognized that this is ambiguous language, as the scope of the coverage via compliance is not defined. And even though Chevron was at stake in those cases, the determination of ambiguity is a judicial one that is made without regard to an agency's interpretation. We'd also like to mention, with regards to the regulations and disclosure requirements, while opposing counsel is correct that as far as EPA and VDEP tables go, these pollutants were not listed. But there is a disclosure requirement if you're asked about it, and there is no requirement in 122.21G13 about formality. If you read the text of the regulation, it's nowhere included. Therefore, we do not agree with the contention of opposing counsel that some sort of formal mechanism is required. And frankly, this was in writing from the Deputy Director of VDEP. We believe that is sufficient to give COMGEN notice to fulfill their disclosure requirements. Moving on to, go ahead. Your Honor.
They asked about it, but then didn't include it. I mean, you know, the fact is that they asked about it, they put it in writing, there was an email, and then didn't follow up on it in terms of that. So why shouldn't they be protected if it's not in the permit?
It's a good question, Your Honor. Again, turning back to Piney Run and the disclosure obligation imposed in that situation, we believe that it's inappropriate to allow a private.
That's assuming that Piney Run is still
Assuming that Piney Run
applicable,
is still
correct?
applicable. Yes,
We
Your
have to
Honor.
get through that hurdle first, right?
Yes, Your Honor. But even if it's not applicable, we believe that it is not a prudent decision to allow a private company to lie to regulators and then get the permit defense. As Your Honor's noted.
Isn't that's kind of the point that I'm getting at. It's kind of a two-way street. Yeah, they didn't tell the truth, but you know what? your person was aware of the situation and didn't find it necessary to necessarily include it in the permit. So why shouldn't ComGen be able to rely on that?
Well, Your Honor, we believe that.
And why shouldn't we favor the attested written permit documents over some informal email?
Well, we believe, Your Honor, that the attestation clause applies to all of the disclosures that ComGen makes, and according to precedent, which, assuming it applies, that is the case. Briefly, I'd like to address the second issues.
Sure.
We'd like to note that this court recognizes correctly that as far as eminence goes, there likely is eminence here, and ComGen is asking this court to essentially state that, no, we have to wait until somebody gets harmed. It's, as you said, kicking the can down the road, but it's more kicking the cadmium down the hill to the river that people drink from and recreate in. Your Honors, we don't think that this is a prudent course of action to pursue, and we believe that we have established a mechanism, and our complaint is the adequate. Your Honors, may I complete my sentence?
You may complete your thoughts, sir.
Yes, thank you, Your Honor. We are alleging that the plan, when completed, is not adequate, not right now. Your Honors, we ask that you please reverse the lower court decision. Thank you.
All right, thank you. Thank you, counsel. We'll take a brief recess and come back with our decision.
us know whenever you want. We have a question.
Please be seated. As the presiding judges in this matter, we first wanted to take just an opportunity to congratulate all of the participants for what a magnificent presentation. The fact is that being able to decide winners and losers, there are no losers here. Everybody is just fantastic. The three of us have participated in these events before and can tell you that the level of competition and the performance by these teams today is just absolutely outstanding, and you should all really be proud of your performances, and we applaud you. So I will give you that. The one thing that I always try to say whenever I get asked to do these is that thank goodness I'm not in law school anymore. Or have to stand on that side of the podium. It's much easier to sit up here and be able to ask questions and do that than to be able to think so quickly on your feet and have the answers and have all of the information memorized that you do. I am in all of your talents.
Go ahead, Judge.
Oh, I forgot to mention, and to have to sit in front of Judge Alley with his grilling questions.
Yeah.
Yes, everybody knows.
That, I was gonna, when we were back there talking, I know as a state court judge, I had the opportunity to sit on the Supreme Court a few times, and I think Judge Alloy did as well when he was a state judge. And you all endured probably the hottest bench that I've seen at one of these before, because at no actual argument have I seen that many questions, and you all handled them very well, and I was actually very impressed by the poise that every one of you showed in answering those questions. You were all excellent. So.
Yeah. No, really, just outstanding. And the truth is, during the argument, it's much easier to be on our side of the bench, right? It's easy to ask the questions, you have to answer them. But then it gets much harder on our side of the bench when we have to write a decision, because you really do, you realize the impact of it. Really outstanding. I think I've judged this every year we've done it, and we haven't had better teams. I can say that. And that says a lot, because we've had good teams, and you really should be extremely proud of yourself. You can ask nothing other than, that you present the issues that you have in a way so the court can understand it. And you did that. I don't have any questions left. And you answered them in a way that was very helpful to me. And sometimes I ask the question in a way because I'm not, different judges approach it differently. But, if we're not going to be worried about the people downstream, who are? who is going to be worried about them? And how do we address that? And I think it's always important from my perspective that everything you do has an impact, right, on our community. And how do we do this in a way that that really does our role in making sure that we have a civilized world? And so, yeah, those are the questions that I always want answered. You know, the law is often cold comfort, and it's there so we can find a way to live together in a world that takes care of everyone, even ComGen. So, yeah. So, anyway, no, you guys were outstanding. Really, really enjoyed hearing you.
And this, although this is a competition, the issues that we're addressing and the issues that you've had the opportunity to research are important issues. And, you know, your knowledge of this area and hopefully your continued pursuit of this area of the law will benefit all of us
Yeah,
in the future.
Absolutely. Let me say one other thing. I taught Appet also here at our law school. I would have given you all A pluses.
Well, you still
And
can.
I still can.
You still can. You can
But
take it
they
back
tell
with
us, but they tell us that we have to pick a winner, which, you know, is,
Yeah,
again, the
that's-
world we live in. But, so here we are.
All right, well, let's go down to the well. We wanna, do you mind if we come down and shake your hands?
Yes, well, that's, in the Fourth Circuit, they always come
They always
down
come down
and
and shake
shake the hands of the presenters.
Right?
That's
Okay.
it.
All right, well, we're going to announce the winner, and, you know, I know that it's kind of one of these things that anytime they have to announce a winner, it's like, oh, this is really hard to say. It was. I mean, this is, there is no winners and losers, they're all winners in this case. So, under the circumstances, as a panel, we have elected to award the winner of the competition to the team from ComGen, which I understand is the team from LSU. And I understand that this is just a temporary certificate, that you're gonna get some more hardware later.
Black with a check.
Like, yeah, with a check. Gentlemen, come on up. Yes, thank you. This is your runner-up certificate after all of this competition, but they will get you some more
So
hardware.
you the photographer?
I am.
Okay, well, let's,
How do you wanna do this?
how does this work? Well, let's do one first and we'll do
okay,
all
yes.
first and do those.
Yes.
Yeah. Guys, get in the middle.
You guys get in the middle.
There you go, how's that? There we are, how's that? Oh, wait, there he goes. Oh, there's, all right. Whoa, this is
How long
good.
have you been licensed in terms of this weekend?
Yeah, a little light.
How many times have you checked?
How many rounds did you have to go in?
Hey, you ready?
All right, everybody, look at the little birdie.
We got a couple more. Good. All right, thank you so much.
Yes, congratulations. Guys, absolutely, really.
You guys, outstanding.